Hi, and welcome to my review video I promised you I would make. So sit back, relax. I'm going to kind of, don't think about it. My dog's trying to spill my drink, which is not good. That's a big no-no in my house. But anyway, we're here for the review video. So this is going to be the information that I think of, that I think is fair game for the, for the first exam. I'm going to go right off the review sheet. So if you have the review sheet, you can follow along. Obviously, doing this at your leisure, so pour yourself a little drink. Drinking a little bourbon and Coke. Got my bourbon right here in case I need another one. And relax, and we'll have a drink together and talk about what I think is fair game for the exam. I hope this thing is recording. My daughter's not here to tell me how this works, so I don't have any real way to know. Hold on. Oh yeah, it is recording. When you get old, they make those little numbers so damn small you can't see them anymore. You're like, how far away? Anyway, so exam number 1. So just want to kind of go through what we talked about and what I think is relevant. So the first chapter we talked about was basics of law, the sources of law, and different theories of law. So the first thing we talked about is the difference between civil and criminal law. Again, civil law is one party suing another, seeking usually monetary damages. So the example we used in class is when O.J. Simpson allegedly killed his ex-wife. Again, have an ex-wife. I'm not judging the man. As I've said, we've all been there where you thought, if they had a horrific accident, might not be the end of my world. But anyway, I know, I'm a bad person. But anyway, civil law, right? So O.J. Simpson got tried criminally in Los Angeles and was acquitted, found not guilty. Then he got sued civilly in Florida and was found liable, civilly liable. So the criminal action was, again, the people of the state of California versus O.J. Simpson. The civil case was trying to recover damages from him by the families in Florida. Keep in mind what the parties are and the different burdens of proof, right? Criminal must be proved beyond a reasonable doubt. Civil law only needs to be proved by a preponderance of the evidence. More likely than not that it happened. And that's how in the O.J. Simpson case we got 2 different results. We got a result where he was found not guilty because presumably they couldn't meet the burden beyond a reasonable doubt, but when they went to Florida, they could prove it by a preponderance of the evidence. We also talked about the remedies, the criminal remedies for punishment, criminal sentence versus the civil remedies of monetary damages. We also then talked about a little bit about what constitutes law. You stay away from that drink. Don't even think about that. My dog is going to drink my drink, and then she's going to be wild. She's already wild. But anyway, we talked about what constitutes law, right? Constitutions, right? The written law that was passed when the state started or when the U.S. started, and as well as some amendments there. Statutes that are written laws that are passed by the Congress and then signed by the governor or the Congress and then the president. That will be written laws and statute books. We talked about cases that were legal precedent. Again, cases where a higher authority has ruled on something, like the example we used in class is Arizona v. Miranda. The United States Supreme Court said that in order to waive your rights, all police officers, when they have you in custody, must give you these rights. You have the right to remain silent. Anything you say can and will be used against you from the court of law. You have a right to an attorney. We've all heard those on every single cop drama show in the world. Those all come from the court case of Arizona v. Miranda, which is that legal precedent. The legal precedent says that courts, even U.S. Supreme Court, can affect the law as it relates on both levels. The last place we talked about what constitutes law is legal journals, like written scholarly journals where people say this is what the law should be. We talked about that as well as the UCC or the restatements of law. We talked about different theories of law, natural law, that there's some intrinsic law that we should be trying to follow. We talked about legal positivism and legal realism. This dog is going to get my drink and I'm not going to be happy. Chapter 2 is business ethics. There we talked about some different theories of ethics and the trolley car dilemma, right? Remember the trolley car? You're driving the trolley car. If you keep going straight, you kill 5. If you turn to the right, you kill 1. And remember that, and which one is which and why. We also talked about business law versus business ethics, and that they're really different fields. That business law is a little bit of a different field than business ethics. That business ethics is a little bit more than law, and maybe things that are legal aren't necessarily ethical. And maybe things that are ethical, maybe not even legal. So a little bit different feel for those things. But being able, so realize that there's some difference there. Finally, we talked about the theory of business ethics. Ethical relativism, right? That ethics is all relative, that you don't really have any real ethics on things. And whatever you decide to do is fine. Absolutism is that there's some set rules, right? We said like, thou shalt not kill. Pretty hard and fast. Don't kill. That doesn't mean you kill the guy in the front yard and drag him back into your house. It means you don't kill. Even if your own life is in danger. If the rule is thou shalt not kill, it means you can never kill. Consequentialism, that's where we talked about that you look to the consequences. So this is where utilitarianism falls, where we look for the greatest good for the greatest number, right? That's when we were driving a trolley car and we said, how many people turn to the left or turn to the right and kill one? And 85% of the hands went up. They were applying consequentialism, utilitarianism, seeking the greatest good for the greatest number. Hey, Jeff, if I got to kill somebody, one is less than five. The next theory of ethics we talked about was ontology, or categorical imperative. And that was the one where you look at duties. What is your duty to act? So in the 1 versus 5, those are the people that said, hey, you know, Jeff, I killed the 5 because I can't choose to kill the 1. Also, likewise, when we were talking about pushing the fat business law professor off the bridge, I'm working on it. I bought a treadmill. It's actually sitting in the other room. It's not doing anything. It might have some clothes on it. Might have some laundry on it. But anyway, I got a treadmill. I'm working on it. But those of you who were not willing to push the business law professor off the bridge, that was applying a more categorical imperative approach, where you have duties and rights, and your first right is not to kill somebody. And almost all of you said you don't kill the business law professor. I have had people in the past tell me they're going to push my fat ass off the bridge, which scared the crap out of me. I didn't know whether to fail him or give him an A, just to keep him up. Don't come to class, just take an A, I swear. Don't hurt me. Anyway, next one was virtual ethics, where we said ethics was based upon virtual behavior, right? Courageous, honesty, things like that. As long as you're acting within those type of qualities, you're doing good. And the last one was ethics of care. And the ethics of care basically said that, I think the dog's getting on the treadmill. Shit, you're going to see this stuff. I don't know what she's doing. Uh-oh, she's got something. We're in trouble. Ethics of care said that we were going to look at how our action interacted with human relationships, and that we were putting some value on different human relationships. This is when I said, okay, rather than turn to the right, there's a pregnant lady on the railroad tracks, or a young child, or to put my son's Cooper's words, somebody I like, one of my friends. So you're not willing to kill that person. You'd rather kill the 5 than to kill your friend. Ethics of care. The next thing we talked about is jurisdiction of the courts in Chapter 3. Let me see how I'm doing on time here. 9 minutes. I think I go about 15 minutes on these and then they die. So I got to keep an eye on them. I'm going to have to do 2 videos. But that's okay. It's good for you guys. Jurisdiction of the courts, we talked about original jurisdiction, right? Jurisdiction where you go to the trial, where you see a trial, you see a jury, you see a judge, you see questions of fact. We also talked about appellate jurisdiction, right? When you appeal something and it goes to the appellate court, and how the appellate court interacts, and the different appellate courts. The state court is the state circuit court is the court of original jurisdiction, to the Court of Appeals, the District Court of Appeals, and then finally to the Wisconsin Supreme Court. In the federal system, it's the Circuit Court. I'm sorry, now I got this wrong. It's the U.S. District Court. Dog, stop! And it applied, she's crunching on a bottle over there. It's annoying the hell out of me. Now she's doing it on purpose. Go from the District Court, the U.S. District Court, to the Circuit Court, the 7th Circuit Court of Appeals. This is the one we're in here. Next thing we talked about personal jurisdiction and how personal jurisdiction was established or obtained. Personal jurisdiction is, again, the court's ability to rule over. Okay, I think we had a bit of a technical problem there, but I think I'm back. So personal jurisdiction, I think that's what we were talking about. Physical location state, right? You're physically in the state, so they can assert jurisdiction over when the court can act on your rule in accordance to your rights. Or long-arm statute, when the court can execute by doing certain actions within the state. We also talked about in rem jurisdiction, right? In rem is about property. So if you're litigating about property and the property's in that state has personal jurisdiction over you. Next thing we talked about was subject matter jurisdiction. And there were three aspects here. One, exclusive federal jurisdiction, right? There's a laundry list of things that were exclusive federal jurisdiction. Then concurrent jurisdiction, which meant the courts could be in the circuit, it could be in the state court or the federal court. And those were a federal question. So some question about federal law that's not on the exclusive list. And or diversity of citizenship, right? Citizens of two different states and more than $75,000 in dispute. If neither exclusive or concurrent jurisdiction applied, then it's exclusive state jurisdiction. So the litigation must be in the state. We also talked about the structures of the court, how they work, from the filing of the lawsuit to an answer, to the discovery process where you have the right to send questions to each other called interrogatories or back and forth, things like that, to a pretrial, to a trial, and all through that. Chapter 4, we talked about arbitration, mediation, alternative dispute resolution, so you should know the difference between arbitration and mediation. Arbitration is decided by, you go and have a kind of quasi little court appearance where you fight about things, and it is decided by an arbitrator. Mediator is where you sit down and reach an agreement between the two parties. You should know that arbitration is defined by contract. Both of these are defined by contract, and that they are enforceable as long as they're not fundamentally unfair. The next chapter we talked about was chapter 5, branches of government, how the government checks and balances itself, right? The different branches, how they do that. Then we talked about limiting power of the federal courts and the power of the federal courts. The first thing we talked about was the supremacy clause, right, which said that any action done by a state in violation of a federal law is void. So that's where we get that marijuana is really not legal in Colorado because it's still against the law, still a crime on the federal books. So the supremacy clause says Colorado can't legalize marijuana. Then we talked about federal preemption. Again, is areas of law where just the federal government can act. The states cannot pass laws. Powers of the federal government to act, we talked about the different ones. The Commerce Clause, the taxing and spending, the privileges and immunities, and full faith and credit. We also talked about different amendments to the Constitution. Specifically, the First Amendment is the one I would focus on. Last thing we talked about was Chapter 7 was crime, which is that crime is an act, a voluntary act with intent within causation. And you should know that an act can be a voluntary act or omission, so those 4 situations where your failure to act could result in criminal activities. We talked about the different levels of intent, right? Intentional, knowingly, reckless, negligently, and how those attach to different aspects of law. Each crime will have its own element of intent. We talked about the unusual case of conspiracy, how conspiracy works, right? So conspiracy is an agreement between 2 or more people to commit a crime, and once one overt act has occurred, one act, even if it's not a criminal act, you are all guilty of conspiracy, and you are all guilty for any crime, any conspirator. Damn dog again. Don't have dogs, don't have children. Take it from me. Words of wisdom. Anyway, then we talked about different classifications of crime, misdemeanors and felonies. We talked about corporate liability. We talked about RICO, Racketeering Influence and Corrupt Organizations Act. And then we talked about the purposes of punishment, the 4 different theories of why we punish people. That's what I have for review for this section. As always, if you have questions, zap me a text, zap me an email, give me a call. I'm around to help you. Hopefully this wasn't too long. And good luck. I'll see you, some of you in class Monday. Those of you that are my Monday, Wednesday class. Those of you in the evening class. Study good. I'll be around. Give me a call. Take care. Peace.